Who was one of our law librarians, and she collects a lot of the data for me that I couldn't collect for myself. So she makes all of these things possible. And she got the data very quickly. I needed to work on this. I had a presentation to SOAR on Monday, and I keep recycling this. I'm not going to talk forever because I know you're going to have questions. And some of the things that I'm going to say are very basic, but I'm just going to elaborate on them. I want to focus on our 18th century Constitution and this two-party political system that operates within the structure of that Constitution. Everything that happens with respect to the federal government today finds its source in that 18th century Constitution. Presidents come, presidents go, control of the Congress changes hands, but the 18th century Constitution endures. It embodies 18th century political notions of separation of powers and checks and balances, and we're going to see shortly our constitutional system is as much about the states as it is the federal government. It's a constitution that was supposed to operate without political parties. The framers said, we won't have political parties. They're factions. We'll never have anything like that in the United States. All the people in government will be men like us, born to wealth and privilege with a high sense of public service. Political parties began to form in the election of 1796. They were solid by the election of 1800 between the Jeffersonians and the Federalists. And ever since 1860, we have had two parties, Democrats, Republicans. It's truly two parties. There have been 30 presidential elections since 1900, with a Republican victory in 2016. The Republicans have won 16, Democrats have won 14. Ever since the 1960s, with the exception of 1988, when George H.W. Bush succeeded Reagan. When one party has held the House for 2 terms, the other party wins the next election. I mean, think about this. Kennedy and Johnson, Nixon and Ford, Carter gets only 1 term, but then you have Reagan getting 2, George H.W. Bush is the exception, and then Clinton is 2, George W. Bush is 2, Obama is 2, and now Trump. So Trump was supposed to win the election in 2016, and he did. So also, when one party gets control of the presidency, the other party often flips one house or both in the next election. So Obama wins in 2008, big Republican win in 2010, control of the Senate. Okay, then Republicans gain control, and in 2006, after Bush wins in 2004, the Democrats get control of Congress. Said 2010, then by now, after 2018, the Democrats get control. What goes around comes around. I mean, we truly have a two-party political system. When I talk about the American constitutional system, and I've given a number of lectures abroad in Russia and Holland, most recently in Slovakia, I emphasize the sovereignty of American states. I mean, this is really unparalleled in other federal systems. The American constitutional system begins with the states. First constitutional document is the Declaration of Independence. These 13 states ought to be, and hereby are, free and independent states. What this means is that in American constitutional theory, the sovereignty over domestic matters formerly exercised by the British Crown devolved upon each of the states. The states are independent sovereign. They don't rely on the federal constitution as the source of their powers. Every state, as you know, has its own system of laws, its own courts. Most of the laws that we live under are state laws. And the sovereignty is just an essential part of the American constitutional system. We see this happening. For example, some states don't, the Supreme Court ruled that Congress can't force the states to participate in the Medicaid expansion. Originally, something like 19 states didn't. Ever increasing number of states are choosing to participate. Some states, like New York and Connecticut and California, but not Michigan, have very strong gun control laws. Michigan has recently adopted a minimum wage law, a paid sick leave law. A number of other states have done so too. So the states have an awful lot of power in the American constitutional system. We'll elaborate on that. The men who met in Philadelphia in the summer of 1787 were men of the states. They knew they decided to scrap the weak Articles of Confederation, create a federal government, come up with a constitution for it, but they were concerned about the states. They knew that if you're going to have a federal government, federal laws can preempt. And so we're going to see that they made it very difficult for Congress to enact laws. Think about it. Both houses have to agree, and the president has to agree. So what we're going to explain is that in order to have a law, you have to have a consensus. In order to have a consensus, you have to have compromise. So the rule is no compromise, no consensus, no law. As far as the framers were concerned, gridlock was a good thing. They didn't want Congress to enact laws unless there was a strong national consensus in favor of the law. Okay, how to do representation? Think back in 1787. Big states like New York say, well, we should have a parliament with, of course, representation based on population. Small states like Rhode Island say, wait a minute, we're sovereign. We should be equal, even though we may have less people. Compromise. House represents people according to their respective numbers, close to the people. Apportionment of the House has to be with strict mathematical equality, just a couple of people between each of them. That's the House. But when it came to the Senates were equal. So today, Wyoming, with less than 600,000 people, has the same 2 senators as California with 39 million people. And that's the way it's supposed to be. The House represents people. The Senate doesn't represent people. The Senate represents states. Now remember, until the 17th Amendment in 2013, the legislatures appointed members of the Senate. And with that today, you know, if there's a vacancy in the House, it has to have a special election. Vacancy in the Senate, it's up to the states. The governor usually appoints a senator, but this could be done as well by election if this is what the people want. So the theory of the Senate was that it represented states. It was going to prevent the House. If the House did anything radical, the Senate as an institution was going to sort of hold up on it, take a second look. If you remember the election in 1994, the Republicans got control of both the House and the Senate. Newt Gingrich, we're going to change everything in the first 100 days. Passed a lot of legislation. Most of it died in the Senate. Some of it was modified. The Senate is a check on the House. The House has certain powers. It, of course, has the power of impeachment. Only the House can impeach president or other officers. All revenue-raising bills must originate in the House. The Senate, as the more mature branch, approves treaties by a 2/3 vote. It also must approve the appointment of federal judges, justices of the Supreme Court, officers of the United States, and the like. It has the sole power to try impeachments. So, I mean, you see the difference. The House is elected every 2 years because it's close to the people. The Senate, which after all represents states and originally were appointed by the state legislature, has 6-year terms. Each House sets its own rules. Now, the rules of the House are pretty strict. Debate comes to an end, and they vote. The Senate has allowed unlimited debate, requiring 60 votes to bring a bill to the floor, except for bills that can be enacted under what is called a reconciliation procedure. If you remember, in 2009, the Democrats had 60 votes in the Senate, and Ted Kennedy dies. Massachusetts requires a special election. Scott Brown won the special election. Democrats no longer had the 60 votes. So they had to do what's called a reconciliation bill. I've never tried to understand all the details of it, but it relates to the budget. And they passed it with a simple majority. Remember that there was not a single Republican vote in the House or the Senate for the Affordable Care Act. Pause. This was a setback for the Democrats in the 2010 election. This enabled the Republicans that ran opposed to the act to win a lot of seats, especially in the House, 63 seats. Now it's popular, and now the Democrats are running in favor, and the Republicans are saying we want to keep insurance for people with pre-existing conditions. What goes around comes around. Okay, we're back now. Because the Affordable Care Act was passed under this reconciliation procedure, the Republican-dominated Senate could have repealed it with 50 votes. They just didn't get the 50 votes, but they could have repealed it. Okay, now, during the Obama administration, first term, the Democratic-controlled Senate was frustrated by the Senate's approval to approve Obama nominees. So they changed the rules. It only took 50 votes, except for the Supreme Court. What goes around comes around. Now, when the Republicans took control, they eliminated that exception. Thus, Gorsuch and Kavanaugh were confirmed with 50 votes. Blame the Democrats on that, because they're the ones who changed the rule. President Trump is frustrated because he can't get the legislation he wants. This is before Democrats took over the House. He wanted the Senate to change the rules to eliminate the 60-vote requirement. My former student, the University of Kentucky, Mitch McConnell, who is now the majority leader, wouldn't go for that because he knew that things could change. And he wanted to be in a position to block legislation. So the rules of the Senate, 60 votes, except for bills enacted under the reconciliation procedure, which is why the tax cut must expire in 2025, and confirmation. I want to I just want to say one thing about the legislative process. As we said, both houses of Congress and approval of the president. Note that the Constitution doesn't use the word veto. It says approval or disapproval, because whenever the Constitution talks about the president, they're thinking about George Washington. So the idea was that if Congress disagreed, if the president disagreed, he would send a message to Congress explaining his reasons why. Congress would listen respectfully to it. If they disagreed strongly enough, by 2/3 vote in both houses, they would override the veto. This is before politics. With politics, it's virtually impossible to override a veto. Probably the Republican dominate, because you need 2/3 vote in both houses, but probably both houses would have vetoed the bill, would have overridden the president's veto of the bill imposing sanctions on Russia. The appropriations bill, the president threatened to veto it, said he was very unhappy with it, but in the end he didn't. Could that have been passed by 2/3 vote? No, nobody knows. In any event, finally the appropriations bills show compromise. The Republicans wanted a big increase in military spending. They got it. Democrats wanted a big increase for domestic spending. They got it. Compromise. The bill passes. Big deficit, but nobody cares about the deficit. I don't pay any attention to that. It just surfaces politically. You're not going to win elections by running. We're going to cut benefits and raise taxes in order to bring the deficit down. Let's talk about the election. In the first place, unlike parliamentary systems, such as Canada, where the voters vote for a slate, we vote for candidates. Remember, the Constitution said no, didn't contemplate political parties. And so candidates can win elections. Individual candidates of one party can win an election in a state dominated by the other party. I mean, Montana is a very red state, but Senator Tester managed to win re-election, and the Democrats happened to have elected the governor in Montana. Democratic governor wins in Kansas. Republican governors in Vermont, Massachusetts, New Hampshire, and Maryland. There are Republican House members from California. A lot of them lost, but you still have about 8 or so. There are Democratic House members from Texas and Alabama. A Democrat happened to be elected in a special Senate election in Alabama. Candidates win. And look at some of the close, even in Georgia, because now we have a highly contested race in Florida. Texas, you got a very significant challenge. Candidates run. Party labels are very important, but they're not totally decisive. Redistricting. With highly efficient computers, it's possible to draw congressional districts in a way as to give one party advantage over another. Even though the House vote totals typically show Democrats ahead or at least even, Republicans had big majorities in the House. Just for a couple of reasons. One, Republican-controlled legislatures in a number of states draw the districts. In Michigan, after the 2000 and 2010 census, the Republicans controlled both houses, and there was a Republican governor. They drew up the House districts so as there would be 9 Republican-dominated districts and 5 Democratic districts. We'll talk in a bit about how that's changed. Usually redistricting is done by the legislature. Michigan has changed it now. It's going with Prop 2. It's going to be done by a redistricting commission, 5 Democrats, 5 Republicans. I think it's either 4 or 5 independents. Certain criteria, and it will advantage the Democrats. Because what the Republicans have done is to draw districts in such a way to try to emphasize rural, ex-urban areas, maybe with advantages 55 to 45. Democrats tend to be in the urban and metropolitan areas. So you have a district with Detroit that's probably maybe 90% Democrat. So it's like Democratic votes are wasted, and Republicans have majority Republican districts with smaller amounts. So the Republicans went into this election, as in the other years, with a big advantage in the House because of redistricting. Despite this, how was it then that we should ask, why is it that despite the Republican advantages, the Democrats managed to win at least 32 seats, maybe more? Everybody is searching, I think, searching for the answer. I put a lot of emphasis in demographics, changing demographics over this long period of time. Demographics have changed in Oakland County to some extent. You have more African Americans living in Oakland County tend to vote Democratic. I think there's been a movement of young people into parts of Oakland County. In any event, 2 Republican-held House seats in Oakland County flipped to the Democrats. So instead of 9-5, it's now 7-7. The Republicans, the other thing that happened in 2008 was the turnout was substantially increased over what it had been in midterm elections. Now, it may be Republicans as well as Democrats, but if you look at the different demographic groups, we see that the 18 to 29-year-old tranche voted heavily Democrat. The 30 to 44% also voted Democrat. The middle ones, middle-aged people, 45 to 60, slight Democratic majority. Republicans still get a majority among the over 60s, but it wasn't as big as it had been before. I must say, I had it wrong. I saw the way the districts had been gerrymandered in favor of the Republicans. I think I said last time it's going to be very difficult for the Democrats to get control of the House. Obviously, I'm wrong. And it goes back to the Constitution, the idea that members of the House represent people according to their respective number. A lot of people changed their vote from times past. Because in the previous Congress, the Democrats had 193 seats. If they now have 232, that means they've picked up 39 seats. That's a lot, especially since it's pretty underrepresented in the House. Now, the Republicans lost seats, of course, in heavily red states like California, New York, New Jersey. They also lost seats, a seat in Oklahoma, seats in, let's see, where, I guess that was the surprise. But again, you have seats lost in Texas, in Florida. So, I mean, it was a Democratic wave. If you look at the demographics, the Democrats did very well relatively, among white suburban women, particularly white college-educated women. Now, when we break the vote down on racial grounds, and this is virtually any election, the Republicans tend to get a majority. and this is early data, it's based on exit polling, but it gives us some idea. Jan collected it for me, so we had it ready to go. Let's see, how we do it. White, according to the exit polling, let's do whites. Men favored the Republican candidate 54 to 49. White women were split, 49-49. But that's just if you look at the overall term. Racial minorities, I mean African Americans, over 90%, Hispanics, 69, Asians, 77. Racial minorities vote heavily Democrat. That is what makes the difference in elections, where majority whites vote for Republican and minorities heavily for Democrats. According to exit polls, in the 2016 election, 53% of white women voted for Trump. I mean, if you go analyze some of the loss, I know some of my women friends don't like to hear this, but there was a lot of dislike of Hillary Clinton, including among women. You know, it was expected that she would do very well among women, and it didn't happen when it came to white women. So, but while white women were split 49 to 49, now again, these are rough estimates, white college women favored the Democrat 59 to 39, while white non-college women favored the Republican 56 to 42. Now, while college men favored the Republican only by 51 to 47, white non-college men favored the Republican 66 to 32. So what this tells, and I put a lot of emphasis on demographics. As I said, overall, whites favored the Republicans 54 to 44, but the minority vote was heavily in favor of the Democratic candidates. Again, we talked about age. Actually, age 65 plus, Democrats came very close. So, what this tells us is Democrats did very well, of course, among racial minorities, had a substantial advantage with college voters, distinct advantage with women, and with younger people. Republicans have very strong support among white men, especially non-college white men. For old-line Democrats, it's very hard to believe that we have lost the support of white working-class men, but the polls indicate that we have. The reason. But you know, there's a local thing. Obama carried Macomb County in 2008, 2012. Trump carried it overwhelmingly in 2016. Why is that? There are many explanations for it. I suspect that a lot of it had to do with the fact that white working class men, blue collar workers, believed that Trump would help their economic situation. A lot of evidence it hasn't, but then the cultural thing comes in. Trump is a man's man, right? He shows all the great things, he grab women and so forth, and whatever it is, it plays well. I want to talk about the Senate. Now, assume that the Republicans can win in Florida. Democrat has won in Arizona and Nevada. Republicans won in traditional red states, Missouri, Indiana, and Missouri, Indiana, and
North Dakota.
Missouri, and North Dakota. Democrats managed to hold on in West Virginia and Montana. If you look at the 2020 Senate election map, Democrats are going to have a hard time holding on to the Doug Jones seat in Alabama, especially if Jeff Sessions runs for Senate, as it's rumored he may do. There aren't that many competitive Senate seats in 2020. Maine is probably competitive with Susan Collins. Ernst in Iowa, Gardner in Colorado, then you have Tillis in North Carolina. There's another open seat in Arizona. If the Democrats win the presidency, they just need to pick up 3 Republican seats. Assuming the Republican advantage is 53 to 47. Democrats have a net gain of 3. It's 50-50 with the Democratic vice president with a deciding vote. Final note on the states. The Democrats did very well in the governor's races, replacing 7 Republican governors: Michigan, Illinois, Wisconsin, Kansas, Maine, Nevada, and New Mexico. The Republicans had a big lead in governorships. It's now dropped to 27 to 23 or something, so I'm pretty sure that's about it. Democrats gained control of some houses in state legislatures, but states still favor Republicans because a number of states are predominantly rural. In any event, at the moment there are 21 states where the Republicans have complete control, both houses of the legislature and the governor. 14 where the Democrats have complete control. And that's a Republican drop and a Democratic gain, including the number of divided houses. I mean, all in all, the 2016 election was pretty good for the Democrats, and our two-party system is now more balanced than it was prior to the midterm. While I could talk forever, and usually might, I think we can do more by becoming interactive and responding to your questions and comments. So, who will begin? Yes?
What's the mechanism or reason why the House can come up with articles of impeachment, but it require a vote in the Senate to impeach the president?
To convict. See, it's important to understand that the word impeachment means call into question.
Okay.
I did an op-ed in 1998 when there was talk about the Clinton impeachment. The framers gave the House the sole power of impeachment because the House was close to the people. The idea was there would be no impeachment unless there was an overwhelming demand from the people as reflected in the House of Representatives. Where did impeachment come from? It came from British parliamentary practice. Now, we didn't talk today about the enormous powers of the president. That's a separate thing. And so they were very concerned. What's going to happen after George Washington? What do we do if we have a bad president? Well, remember, they wanted to control the election by means of the Electoral College. They didn't trust the people to elect the president. The idea was that the people would elect wise men, and each state would have electors equal to the number of representatives and senators, and they would go and they would select a wise man to be president. But in case they made a mistake, the framers wanted the people to decide. But when it came to an actual conviction, that was for the more the more careful, the more conservative branch in the Senate. And that's why it's a 2/3 vote. Note also that the Constitution said treason, bribery, or other high crimes and misdemeanors. That doesn't mean criminal offenses. That term is also taken from English parliamentary law. It meant a serious breach of official duty, a serious abuse of power. That was the basis for the Nixon impeachment. Note that Nixon was impeached when the Democrats had a majority of the House. The conviction in the Senate was due to the fact that the Republicans abandoned him. And Barry Goldwater and other Republican leaders went to Nixon and says, "You're going to be convicted in the Senate." At that point, Nixon resigned. During the Clinton time, where Ed said it has never been understood, but part of the definition of high crimes and misdemeanors to impeach the president for something that had nothing to do with his official duties. So the House, in effect, added a ground for impeachment. Serious violation of the federal criminal law, because Nixon committed perjury, lying about his prior sexual relationships in response to a court order in the Paula Jones case. The fail-safe was that if the Republican strong majority opposed impeachment of Clinton, but a majority of Republicans favored it, and therefore the Republican-dominated House, responsive to its constituency, impeached Clinton. Now they knew that they'd never get a conviction in the Senate. And in fact, when the two counts were voted on, one was 50-45 for acquittal, the other was 50-50. They weren't going to get the 2/3 vote. And forget about any talk of impeaching Trump, at least at this point in time, unless there would be some absolutely incredible revelations in the special counsel's report. He won't be impeached. It's not politically advantageous for the Democrats to impeach Trump. He won't be convicted by the Senate. He may get some sympathy. Public opposes impeachment. Republicans lost seats in the 1998 election with the Clinton impeachment. And besides, from the Democrat standpoint, it's better to run against Trump than it is Pence. So much as you might get some opponents of the president might be satisfied, might get a good feeling from it, it's not politically astute. And politicians do things that are politically astute. But that's the answer. It's why we have this setup on impeachment. The House, which is close to the people, decides whether to impeach. But the Senate makes the ultimate decision. And it takes 2/3, just as it takes 2/3 for a treaty. Yes?
When they talk about voter suppression, what are they referring to? And is that something that's actually, can people be put in jail for doing that, or is it just a political thing? I don't understand it.
It all traces back to our 18th century Constitution. Under the Constitution, the states set the qualifications for voting. All voting is done in the states. And states can make the rules about who are eligible to vote. Subject, of course, like any other state action, to the requirements of the federal Constitution. Republican-dominated state, well, let me go back to something like voter ID. Voter ID has long been in effect in Michigan. There has never been any complaint that it's administered in such a way as to be disadvantaged to low-income people, racial minorities. Apparently, it works very well in Michigan. Other states, especially southern states, have more strict requirements for voter ID. It won't be accepted as a voter ID. And in some cases, it has been shown, like that North Carolina, that these requirements were adopted with the intention to dilute the votes of African Americans, Hispanics, racial minorities. But what I want to emphasize is that both the qualifications to vote and the administration of elections are done by the states. Now, you may or may not have paid a lot of attention to Prop 3 in Michigan. As of now, you had to be 60 or older to have an absentee ballot. First few years after my wife and I turned 60, we liked to go to the polls. Then we realized, why wait at the polls? Just sit down. Now, absentee ballots for anybody who wants one. Makes it much easier for older people, people without means of transportation so easily, people who can't take off for work like we do. They can just sit down and vote. Election day, registration. And the Republican legislature eliminated straight party voting. As you may, Prop 3 restores straight party voting. So the specific answer to your question is that in some states, the government has used its control over elections to try to make it more difficult for lower income people and minorities to vote. And it goes together. We have a great income gap, especially between whites on the one hand, African Americans and Hispanics on the other. I mean, when we talk about low income people, in the urban areas, we're talking about African Americans and Hispanics. In the rural areas like Appalachia, in Kentucky, where I was from, you're talking about rural whites as well. And I don't know how the voting breaks down among rural whites in terms of income. We know that overall figures show that lower income people vote heavily Democratic, while upper income people vote Republican.
Let's ask the question, piggyback on his question, in regards to voting suppression. We know in terms of the Voting Rights Act 1965, I think it's Part B, that section part was removed, whereas it allowed the state to, I guess, have more manipulation in terms of African Americans, people of color.
Well, here's the thing. The Voting Rights Act of 1965 prohibits racial discrimination in voting. You've had some cases where it's been shown, like in North Carolina, that voter ID laws and other laws were adopted with the intent to keep down the African American vote. There is another provision called pre-clearance. It applied to 9 southern states and some areas where voting by minorities was historically low. Those states were required to get Department of Justice pre-clearance for any change in election laws. And while most changes would be approved, the Department of Justice could deny pre-clearance to laws that diluted the voting power of racial minorities. Now, Supreme Court said that that provision is unconstitutional because it's based on one that states are treated unequally, which is not the way it's supposed to be. But secondly, it's based on conditions as they existed in 1965, where you had very low African American voting especially, and that's changed. So the court said that those provisions are no longer operative. But the ban on intentional discrimination is nonetheless, this has made it, removing pre-clearance, has made it easier for some of the southern states to enact voting rules that discriminate against minority persons.
Over here.
I have a question about the courts.
That's another lecture, go ahead.
Oh, I know, but it's connected because McConnell has been approving unprecedented numbers of federal judges. And how do do you understand that then?
Well, I thought you were going to relate that to the Supreme Court.
Well, yeah, you
The
can bring that in.
two go together. This really is an interesting question. As many of you know, in my younger days, I'm very old right now, I used to litigate a lot of constitutional cases, mostly as a volunteer lawyer for ACLU, both first in Kentucky and then here. This included the Kentucky version of Roe v. Wade and the like. And a lot of the judges, especially in Kentucky, were not very sympathetic to the cases. But it had been my experience, both litigating in Kentucky and Michigan and elsewhere, that most federal judges were respectful of Supreme Court precedent, and they tried to stay within the parameters of Supreme Court precedent. But at the same time, they had certain discretion. I was trying to get a new issue. Let me give an example. As many of you know, I was one of the lawyers, along with Dana Nessel, Michigan's Attorney General designate, challenging Michigan's ban on marriage for same-sex couples. Why was it that our case got to the Supreme Court? And by the way, our case was named DeBoer versus Snyder after April and Jane. Why is the Supreme Court case called Obergefell? Well, the Sixth Circuit that ruled against us covers Michigan, Ohio, Tennessee, and Kentucky. The Ohio people got their petition for certiorari up to the Supreme Court before we did. So although the cases are consolidated, it's named Obergefell instead of DeBoer. But when the cases came to federal courts of appeal, that's the intermediate court, with the exception of one judge in the Seventh Circuit, the way the justices lined up depended on whether they had been appointed by a Democrat or Republican president. In 4 other circuits, a majority of the judges had been appointed by Democratic presidents. We drew 2 Republican appointees and 1 Democratic appointee. So there was a split. That's why our case got reviewed in the Supreme Court. So see, this is where the judges can make a difference. Even though the conservative judges will stay within the parameters of precedent, they apply it differently. Recent case from the U.S. Court of Appeals for the Fifth Circuit, which covers Texas, Alabama, and Louisiana, almost totally dominated by Republican appointees. Louisiana had a law requiring doctors performing abortions to have admitting privileges at local hospitals. Now, abortion is an extremely safe medical procedure. Highly unlikely that there'd ever be a reason to admit a woman to the hospital, which means that doctors at abortion clinics, unless they have a pretty substantial OBGYN practice, don't admit enough people to qualify for admitting privileges. And of course, in conservative states like Louisiana, when you get outside of New Orleans, there's going to be prejudice against doctors who perform abortions. Now, Supreme Court ruled in a case from Texas in 2016, Whole Women's Health, that the states could not enact laws that impose an undue burden on a woman's ability to obtain an abortion. Well, Texas had the same thing about getting hospital admitting privileges, and it also required abortion clinics to be equipped like an emergency surgical facility. It ended up that perhaps in the whole state of Texas, there might be 8 abortion clinics. So the Supreme Court said this is an undue burden. That's while Kennedy was still on the court. Now that's binding law. It's not going to change. You get this court in the Federal Court of Appeals in Louisiana and say, well, we have to apply the Supreme Court precedent. Well, here's a doctor in Louisiana that has admitting privileges. Here's another doctor. There's no undue burden. Women in Louisiana have full access to abortion. The provision is constitutional. You had another case coming from from Indiana, which is the Seventh Circuit, covers Indiana, Illinois, Wisconsin, where a majority of the judges have been Democratic appointees. Indiana had a law requiring the doctor doing an abortion to do an ultrasound, which doctors do routinely. But then the woman had to wait for 18 hours before she could have the abortion. Sort of, you know, an effort, or like a 24-hour wait that we still have in Michigan, well, maybe the woman will change her mind. Of course they don't, but it's hassle. Of course, doesn't prevent any woman from getting an abortion. Nonetheless, the U.S. Court of Appeals for the Seventh Circuit ruled that's unreasonable. There's no valid reason. Now, what I'm getting at is you have law. I think the Louisiana law is more burdensome than the Indiana law. So the appointment of the judges make a difference. Maybe next year we'll talk about the Supreme Court. I mean, you've heard all kinds of it. Don't pay any attention to it. They're not going to go and say, oh, we're going to overrule all the decisions we don't like, starting with Roe v. Wade. Court doesn't work that way. Court works as an institution. What you are going to see with a conservative-dominated court is that as new issues come up, the conservative justices are more likely to rule on a conservative side. I mean, we were pretty confident that we were going to win the board because Kennedy had been the justice in the majority, striking down other laws that discriminated against gay and lesbian people. We thought we might get Roberts because he would not want to be on the wrong side of history. It was pretty clear when I was in the courtroom for the oral argument the way it was going to go. I mean, it was like it was wired. It was not as if the justices were asking the lawyers provocative questions, trying to change minds. They were just asking questions to get information for their own opinions. It was pretty clear we didn't get Roberts' vote, but it wasn't necessary. Now, by the way, that's not an issue. Isn't it fascinating how there is just general acceptance of marriage equality for same-sex couples? It's not. It's an overwhelming exception, an overwhelming thing. But you know, the real thing that we're concerned about in the area of sexual minorities are transgender people and sexual identity. There's great acceptance of gay and lesbian people because we know them. I mean, they're family, they're friends, their children are friends, they're co-workers. Hey, it's just not all that different, do we? You know, marriage is marriage. I gave a number of talks about that, just pointing out. We stopped using the term same-sex marriage. We substituted marriage for same-sex people because there's no difference. Marriage is marriage. It's a relationship based on love and commitment, and it doesn't matter whether the people are same-sex or opposite sex. But most people don't know a transgender person. And you won't know a transgender person. You may suspect, but you won't know a transgender person unless that person tells you. And because we don't know transgender people, and I think it's harder. The idea of transgender, of people not being satisfied with their gender at birth, even though we know it's very real, is hard for a lot of people to understand. As a result, efforts to achieve equality on the basis of sexual orientation and gender identity founder on transgender. I think they are easy targets, especially for the haters. You also may have seen that President Trump has tried to issue an order keeping transgender people out of the military. I think it's tied up in the courts right now. But again, we understand it's pretty difficult for transgender people to enlist in the military. That's going to be the battleground. And so let's give an example. You may have seen that the Trump administration is proposing a rule for interpreting the term sex as it is used in Title VII, Title IX to mean sex at birth, which is simply a way of denying those protections to transgender people. Suppose we have a case coming before the court as to whether, there's a recent decision by the U.S. Court of Appeals for the Sixth Circuit saying that discrimination against transgender is discrimination on the basis of sex. It's used stereotype, what is a woman, and so forth. That may get up to the Supreme Court, it may not. Those are the kind of cases where the conservative majority may make a difference. I have no doubt. I think it's interesting. But suppose that marriage equality had come before the court as it's now constituted. One would expect Gorsuch and Kavanaugh, but who knows what Kavanaugh's going to do? But to vote against marriage equality. Question is, would Roberts vote in favor? Would he vote for us because he wanted to be on the right side of history? Not necessary because Kennedy cast the fifth vote. Do not think that the justices of the Supreme Court are immune from value issues or in some cases concern for public approval. I think we've exhausted all your time.
I got one quick question.
Go ahead.
You talked about the Constitution. What can we do about electoral college?
Nothing. It's there.
That's too bad.
Everybody likes it except you. What I think, now think about it, I've written about this.
Okay.
Big states like it, like California, because they have a lot of votes, 55 votes. Small states like Wyoming like it because at least they're not a blip. I mean, their 3 electoral votes count. Both parties like it. Both parties operate in every state. No matter how red the state may be, you're going to see a Democratic Party office. So who doesn't like it? Academics may criticize it. It's with us. Forget it.
That's why.
You have to know what you can do. Do not. This is how we elect our president. It doesn't make any sense. But I mean, I can try. This is why there's no such thing as the popular vote. I call it the what do we want? The claim, the alleged popular vote, or look in France, they elect a president. Go to vote one Sunday. Every vote counts. If nobody gets 50 plus 1, they have an election the second Sunday. Every vote counts. We don't know how many Republicans in California or Democrats in Texas don't vote for president because their vote won't count. Why is the battle fought in about 10 states that are considered swing states? This is how we elect our president. It doesn't make any sense today, but that's what we do. The legitimate president is a president like Trump who gets 307 electoral votes. You need 270, he wins. Note, by the way, he carried 3 states, Michigan, Wisconsin, and Pennsylvania, by a grand total of 77,000 votes. 10,000 votes out of millions in Michigan. While Clinton won the popular vote by close to 3 million votes, she carried California by 4 million votes. So-called popular vote, don't pay any attention to it. The politicians don't, the campaigns don't. They focus on winning electoral votes. That's why they don't campaign in New York or California or Texas, and they're big in Ohio and Michigan and Florida.
Okay.
Thank you.